email the support worker or contact the support worker to provide the advice. So in relation to the webinar today, what is our focus today is obviously the Emergency Measures in the Public Interest COVID-19 Act 2020. And the preamble to that act sets out its objectives, which are to make exceptional provision in the public interest and having regard to the manifest and grave risk to human life and public health posed by COVID-19, and in order to mitigate where practical, the effect of the spread of that disease. So the Act is designed to manage the health risks and the economic impacts of COVID-19 and includes a number of measures that impact on housing that we'll be exploring today. Noticeably in the preamble, there's reference only to the Residential Tenancies Act 2004 and no other housing legislation. And that may be a relevant consideration when we're looking at the scope of impact of the legislation. The draft bill was published on the 24th of March, very late in the day, very late in the evening. It was debated in the Dáil on the 26th of March, debated in the Seanad on the 27th, and signed into law on the 27th of March. And the window for amendments was just a morning of the 25th of March. And this very tight timeframe within which this legislation was produced has implications, we feel, for its drafting and for some of the amendments that were put into the legislation. We'll explore some of those implications in the course of this webinar. The provisions generally apply for the emergency period, which is stated to be a period of 3 months from the commencement of the Act, i.e. until the 27th of June. And there is a scope for extension, and we don't currently know at this stage if it's going to be extended. There have been indications that it will be extended, and there's certainly a procedure for that to happen. So just to go through the structure of today's webinar. So we're very grateful to Nóra Ní Lionsigh, who's with us today, who'll take us through the key provisions of the legislation, sections 5 to 8. Nóra Ní Lionsigh is a barrister at law who practices generally in public and human rights law. She's a former adjunct assistant professor in criminal law at Trinity College Dublin, and she currently lectures in constitutional law at the King's Inns. And we're very grateful to Nóra not only for assisting us with this webinar, but for her support of Mercy Law more generally. The case studies then, myself, Paul and Sinead each have a case study to go through, which we hope will show some of the practical applications of the legislation and may prompt some questions from your side on how they may apply in scenarios that you have come across. And that will lead us into our Q&A, where we hope to answer some questions. We have some questions that have been sent in to us that we'll address to start with. And we'd ask you to submit any questions you have in the Q&A box that you'll see at the bottom of your screen, or to direct them to the host who'll pass them on to us, and we'll do our best to answer them. And if we don't know the answer, we'll do our best to find out the answer and to come back to you. Just to note, any technical difficulties you're having, Danielle, who kindly emailed everybody as a reminder yesterday, is a contact point and will help you with those. And in relation to questions, we're not using the blue hand function, just for those people who are looking at that. Please submit the questions via the Q&A box. We are recording this webinar and we hope to share it more broadly, given that we had such interest in it. And we hope to put it up on our website and social media channels. So just to be aware of that. Okay, so I'm going to pass on over to Nóra, and I'm going to disappear from your screen, and I'll come back shortly. Many thanks.
Okay, so thanks, Rebecca. Hopefully my video should be coming on now momentarily. And so, as Rebecca mentioned, my name is Nóra Ní Lionsigh, and I am a barrister, and I work in public law generally, as well as kind of human rights law and other areas of rights-based law as well. So in terms of what I'm going to be going through today, really I'm going to be focused on one piece of legislation, the one that Rebecca has already mentioned, but just I suppose to mention the broader kind of legal landscape around COVID-19 over the last couple of months. There are two primary pieces of legislation that were brought in to address public health concerns and the various related amendments that were required. There was the Health Preservation and Protection of and Other Emergency Measures in the Public Interest Act 2020, and the Emergency Measures in the Public Interest Covid-19 Act 2020. And finally, there were regulations also brought in on foot of those. So that's kind of the legal architecture that has been brought in to deal with this emergency period. So in terms of the two pieces of legislation then, I just want to mention briefly first the Health Preservation and so on Act 2020. I've been calling it just the Health Act 2020 for ease. And essentially that act brings about a number of amendments to older legislation, the Health Act 1947 and some of the related acts that were originally introduced to deal with public health concerns around tuberculosis and other infectious illnesses. So that's kind of one of the pieces of legislation, and it really addresses a lot of the kind of health provisions. It addresses some of the social welfare entitlements and so on. But chiefly what we are concerned with here today is the emergency measures in the Public Interest Covid-19 Act 2020. And that act it's a real omnibus act, and I think Rebecca has gone through already, I suppose, the speed with which it was drafted, the speed with which it passed through the houses of the Oireachtas, and that naturally gives rise to, I suppose, sometimes some of the quirks in the drafting, and certainly things that lawyers and I'm sure others will be poring over for some time to come. But in terms of what it contains, it has a very wide range of amendments to different pieces of legislation. There are amendments to the Planning Act, to the Residential Tenancies Act, to regulations around healthcare professionals. There's amendments to the Mental Health Act, the Defence Act, the Redundancy Payment Act, and others. And indeed, you may well have heard over the last while discussions in the media and elsewhere about aspects of this. I know certainly the Redundancy Payment Act and its impact on those who are coming back from maternity leave is something that has been discussed substantially, as well indeed as the Residential Tenancies Act, Mental Health Act and so on. But in terms of our focus today, we're looking at housing, and so we're focused in on really quite a small number of the sections of the Act, which are sections 5 to 8, which relate specifically to the Residential Tenancies Act. Although, as we'll come to see, actually their remit is a little broader, even though, as Rebecca mentioned already, we're only actually talking about amendments to the Residential Tenancies Acts. So I suppose an important place to start, and for those of you who are working in particular with those who might be affected by this act and by the amendments, you'll want to know who is protected by the provisions. So who comes within the ambit of this act and who can receive the various protections that I'll set out in a few moments. And certainly it appears from the act itself that any tenant or landlord indeed who is covered by the definitions of the Residential Tenancies Acts 2004 to 2019 will fall within the ambit of this act. If we go to in the interpretation section of the act, which is provided for in section 3, we can see that there are definitions of a landlord, definitions of a tenant, and then we also see a definition of a licensee. But the licensee, so someone who's residing somewhere on a license, appears in this section to relate to a licensee in student accommodation. And I think that's going to arise in one of the case studies, so I won't go into it in huge detail now, but certainly in terms of the interpretation provision, it certainly seems that the references to a licensee are confined to that context, although I don't think it's perhaps the clearest in the world given some of the other provisions. So who else is covered by it? We have landlords and tenants under the 2004 Act. We have licensees in student accommodation who find themselves under the 2004 Act as well. Then we also have, and this arises not in the interpretation section, which is section 3, but later in section 5, subsection 7, we see that local authority tenants are also protected against any proposed eviction during the emergency period. And similarly, any approved housing body tenant is also protected against any proposed eviction during the operation of the Act, rather than the emergency period. So they are also brought into the ambit of the Act by section 5.7. Interestingly, also, we see a reference to travellers under section 5.7. And I've put in a little bit of the detail into the slide there because it says that travellers resident in any location should not during the crisis be evicted from that location except where movement is required to ameliorate hardship and provide protection, and subject to consultation with the travellers involved, which I think is quite important provision, that there must be consultation and somebody can only really be moved on from any location subject to consultation and to ameliorate hardship and provide protection. So it's something that may arise in due course. Another definition, I suppose, or definitional issue here is travellers who are currently resident in any location, and the definition of resident and so on may arise. But I think a broad interpretation is likely to be given to it. But in terms of who we have protected, we certainly have tenants, local authority tenants, to some of the provisions, approved housing body tenants who fall under the Residential Tenancies Act for the most part anyway. We have licensees and student accommodation, and then we have particular provision in relation to travellers. So then I've just flagged about who may not be protected, and in that regard, we flagged that certain licensees may not be protected. Now, there's a little bit of confusion around this, and certainly there's a divergence of opinion on it. If we look strictly at the Act itself, it appears only to refer to licensees who are effectively student licensees, so those in student accommodation. But certainly in a lot of the documentation that's been flowing around the meaning of licensee, and indeed some of the government's own guidance from various different bodies and departments, seems to indicate that licensees may have been intended to be included. So that's something that's not hugely clear under the legislation itself. So that brings us in then, I suppose, to the key provisions. So as I've said, we're dealing with sections 5 up to section 8. And section 5 really provides for the bulk of the provisions, with some kind of ancillary things in 6 and 7, and then on to 8. But in terms of 5, section 5.1 provides in very clear terms that a landlord shall not serve a notice of termination in relation to the tenancy of a dwelling during the emergency period. Sets out very plainly that during the emergency period, so the emergency period, as Rebecca outlined at the beginning, started on the 27th of March, the passage of the legislation, up until the 27th of June, unless it's extended, which is entirely possible. That's provided for in the Act itself. But during that period of time, a landlord shall not serve a notice of termination. So that means that any notice of termination that might be served within that period would presumptively be invalid. It would be in breach of this law for a notice of termination to be served within the emergency period. Section 5.2 in turn then provides that a notice of termination served before the emergency period that would result in a termination date falling during the emergency, it's effectively paused until after the emergency period ends. And the terminology that's used there is in relation to a revised termination date. And typically with interpretation of statutes, you have to, if you read the legislation itself, you have to go elsewhere in the Act to find what a revised termination date means. But in effect, it means that if you were served with a notice of termination at some point before the emergency period, whether that was November, December, January, could be much longer depending on how long you've been in your property, and the the termination date falls during the emergency period from the 27th of March onwards, then that is effectively paused. So from the 27th of March, you press pause on the clock, and the clock doesn't start to run again until after the emergency period is over. And I suppose if we think in more general terms about the purpose of the legislation, and Rebecca helpfully drew out some of the kind of the key parts of the kind of purposes of the Act at the beginning, because it makes very clear that the purpose is to protect public health. And so essentially the one of the key provisions really is to prevent people moving around so that everyone is staying where they are. And so in terms of a notice of termination, and it's also other provisions as well, everything is paused for the period in terms of a notice of termination. So no new notice of termination can be served, and any existing one is effectively paused and the clock stopped until after the emergency period has ended. One thing to say though is that there is, and just before I finish up on this one, is that if a notice of termination was served before the emergency period and it was referred to the Residential Tenancies Board, then and a determination order was made, then that may affect the revised termination date. So if the case is that notice of termination was served back in November or September perhaps, and there was a challenge, dispute went to the RTB, there was a decision made on it, then that will overtake to an extent the revised termination date. So that's also provided for within the Act as well. And again, I suppose we'll have to wait and see how that plays out in practice, but certainly there's a little bit of a saver in terms of any termination orders that have been made by the Residential Tenancies Board. Now, they have published their own documentation and their own guidance on the Act, and that seems to suggest that they'll be taking I suppose a reasonably broad interpretation of things, and one that is to give effect to the purposes of the Act as well. So that may be something that will result in decisions that might be perhaps more favourable to tenants with any luck in due course. But there is a little bit of a saver in terms of a revised termination date. So the next provisions then are first in relation to Part 4 tenancies. And this is one of the sections that perhaps there's a little bit of a lack of clarity on. So Section 5.1b provides that a Part 4 tenancy will not accrue during the emergency period where a landlord is prevented from serving a notice of termination by virtue of Section 5.1a. So Section 5.1a, a landlord can't serve a notice of termination. Then Section 5.1b goes on to say that were it not for 5.1a, a tenant who would not acquire a Part 4 won't obtain a Part 4. Now, there's a little bit of a lack of clarity in relation to that, and I think we may come to that in terms of the case studies later on, because certainly in terms of some of the interpretation documents, it's been suggested that no Part 4 could accrue that wouldn't accrue otherwise during the period. So if you moved in, let's say at Christmas time, it wouldn't be the case that your 6 months will be up now or at the end of this month. Because of the emergency period, but then it seems to relate back to a notice of termination being suggested. So I think that's something that does lack a little bit of clarity, certainly. Then another quite separate provision then, but one that is important and may arise in due course, is Section 5.5, which essentially extends the warning period for a tenant who's in breach of their obligations by failure to pay rent. So ordinarily, there would have been a 14-day warning period required for rent arrears. That's now extended to 28 days. So that provides a longer period of time. And certainly I know in the RTB, their own kind of guidance, their FAQs and so on, they're kind of imploring landlords and tenants to work together in terms of rent arrears and difficulties and so on. And so with any luck, if there is an issue in terms of rent arrears, that there might be a broad enough interpretation taken of it, but it does extend the period of time in any event. Then finally, one of the really important parts of Section 5 is Section 5.7. And that provides in very, very broad terms that notwithstanding any of the provisions in this section, all proposed evictions in all tenancies in the state, including those not covered by the 2004 Act, are prohibited during the operation of the Act. Now, I've noted at the end there that it's notably not just the emergency period, because certainly it appears that all proposed evictions in all tenancies, not just those under the 2004 Act, are prohibited during the operation of the legislation. So it's not just during the emergency period, but during the legislation itself. And so certainly until the legislation is gone, is repealed or otherwise, it appears that this remains in force in terms of any proposed eviction. Now, what's interesting about this is that it clarifies that it includes all tenancies and it includes those not covered by the 2004 Act. Now, again, that brings us back a little bit to the question about licensees, because if you're a licensee, if you're using a rent-a-room scheme, let's say, or you happen to live in a house that's with the landlord, they let a room out to you and so on, then you have a license agreement for the most part. You don't have a tenancy, so you don't fall under the provisions of the 2004 Act. But this seems to suggest that perhaps it is broader, that the provisions here in terms of proposed evictions are beyond the 2004 Act. However, it does say that all proposed evictions in all tenancies in the state. So if you're a licensee, are you within a tenancy? And it doesn't provide for a very clear definition of tenancy within the Act itself. So it could be that it wouldn't include a licensee, which is why I say, and said earlier, there's a little bit of a question mark over the position of the licensee. And it could mean more so here that when they say tenancies, they're referring to those in local authority tenancies and so on and so forth. But it is something that gives rise to a little bit of a question, because it seems to be a very, very broad provision, notwithstanding some of the other parts of the Act. Okay, so that's more or less everything I wanted to say about Section 5, which brings us on to Section 6 and 7 and so on. So Section 6 effectively pauses any rent increase during the emergency period. So even if another rent increase could have come in lawfully during the period, it cannot do so by virtue of Section 6. So again, it kind of presses pause on any rent review or rent increase. Section 7 then is more of a procedural provision than anything else. It removes the requirement that a tenancy tribunal of the Residential Tenancies Board is held in public, which is provided for in Section 106 of the 2004 Act. So it means that if you are someone who has referred a dispute to the Residential Tenancies Board, you will go in the first instance to an adjudication officer or perhaps to mediation, and then if either of those doesn't work out or one of the parties is dissatisfied, then you go to your tenancy tribunal, which is usually a 3-member tribunal, but it is formally held in public, and the 2004 Act requires that it be held in public. But Section 7 effectively pauses that requirement or removes the requirement for the purposes of the emergency period. So again, kind of a procedural issue more than anything else. And as I understand it in practice, there are lengthy delays and difficulties in terms of the RTB sitting at the moment, as indeed there are a call support system in any event. So Section 8 in turn then, and Section 8 is another important section along with Section 5.7 in terms of evictions. It provides that a person served with a notice of termination that requires him or her to leave during the emergency period does not have to leave during the period. However, there is an exception to that, which is where there has been a determination order by either, at that first instance, the adjudication officer of the Residential Tenancies Board or a tribunal of the Residential Tenancies Board requiring the person to leave. So upholding a notice of termination and requiring the person to leave. So effectively, if you've been served with a notice of termination, which requires you to leave, you do not have to leave during the emergency period. However, if that has gone through the process of the Residential Tenancies Board and they have made a determination order that requires you to leave, then you can be made to leave under that determination order. So the determinations orders are still in effect, notwithstanding this other pause on a person being asked to leave under a notice of termination. Now, from a practical point of view, if you are served with your notice of termination, you go through your dispute process and you have a determination order that says that you must leave on X date. To give effect to that, if you have not left at that stage, the landlord, or in certain instances, the Residential Tenancies Board, will be required to go to court to enforce that determination order. So they would have to go to the district court to give effect to that order. And in practical terms, the district court hasn't been hearing civil cases for the last number of months. Under directions of the President of the District Court, only certain cases have been defined as urgent, and civil cases, such as a case like this, has not been defined as urgent. So as a general rule, they haven't been hearing these cases. So as I say, in practical terms, it might be more difficult for a landlord or otherwise who might want to give effect to this, which adds additional even if not principled or legislative protection to a tenant, it at least does provide in some sense some practical protection. Now, it is possible, even with that direction of the President of the District Court, to go, if there's a particular urgency, someone can apply to have their civil case heard. So if a landlord, for whatever reason, thinks that there's a particular urgency that requires the giving effect to a determination order by the court, then they can apply for that. So that is one thing that could happen. But excuse me, it is just important to kind of say that at that stage. So I might move on then just to the next slide there, Danielle, when you get a chance, which is considerations after the emergency period. Now, in terms of these, most of them will be obvious enough, and indeed there may be many others. These are the ones that I suppose occurred to me as I went through the legislation that may arise, and issues that might come up for those working with those with housing issues after the emergency period. So the first thing I suppose to keep an eye out for will be any notice of termination that was served during the emergency period. Secondly, we'll have any unlawful eviction during the emergency period, whether that's a proposed new eviction during the period, whether it's a notice that was served prior to the emergency period that's sought to, I suppose, be effected during it. Any unlawful eviction in terms of time beginning to run, because time has been paused for the most part. So if time during the emergency period is being included for an eviction, that would give rise to issues under Section 6, then any unlawful rent increase during the emergency period, time being used by counted towards a notice of termination and so on. I flagged that already. The warning period not being properly applied for failure to pay rent, so 14 days warning rather than 28 days warning being utilised. And then I flagged as well there just an issue in relation to Part 4, which I think I flagged already has a little bit of a lack of clarity around it, but it's certainly one to watch out for, whether there are Part 4 issues arising down the line, and I think that there are likely to be Part 4 issues arising. And so it may be something that may require some further clarity from the Residential Tenancies Board in due course. So in terms then of the remedies, your key remedy for anyone in a residential tenancy will be an application to the Residential Tenancies Board for an unlawful eviction. You could be looking at an award of damages. For other breaches in relation to time periods, warnings and so on, it could be that a notice of termination is found to be invalid. It could be that an extension of time to leave a property might be given, so it might be a longer period of time to allow somebody. Damages might be appropriate. Now, damages don't tend to be awarded. In many cases, it's often a longer period to vacate a property, or indeed it could be an invalid notice of termination is something that can arise as well. So indeed, there might be other issues that arise here, and certainly I think one thing that is not clear from the legislation and that is clear from the it isn't particularly clear from the legislation is what happens if a local authority breaches the provisions here, because the provisions are really directed more so at the 2004 Act and those tenancies covered under the 2004 Act. If you're a local authority tenant, do you then have some route into the RTB? I can't imagine that you do, but you may have a route, I suppose, to be going then into the High Court, because you're dealing with a public body. So if a local authority seeks to give a proposed eviction, or indeed if travellers who are resident in a particular area are if there's an attempt made to move them on by a local authority, then you may be looking at going into perhaps the High Court might be the more appropriate forum, because it is not particularly clear in the legislation whether those who don't fall otherwise within the RTB remit will have that remedy open to them. So I think that's more or less the main kind of points that I wanted to make about the legislation. Now, as I've said, it comes with the caveat that the legislation was really rather hastily drafted, and so parts of it may lack clarity and aren't always entirely consistent. So I think some of the things they're my interpretations of them. And it may be that in due course a court might take a different interpretation, but I think certainly it's a useful place to start. And I think we'll come back to a lot of these issues when we come to the case studies. So I might leave it there and hand over to Paul, who I think is going to start by giving the first of the case studies. Thanks very much.
So hello everybody. So just to introduce myself, I'm a solicitor here at the Mercy Law Centre. I'd just like to thank Nóra for her contribution. And yeah, so what I was going to do was use a short case study around license agreements to kind of tease out some of the issues that Nóra has highlighted. So yeah, so license agreements are chosen. This case study was chosen in order to highlight some of the uncertain positions that licensees can find themselves in during this emergency period. And as Nóra highlighted, the position of licensees is unclear, and there are divergent opinions. So the scenario that we have here is a client who has been in receipt of a HAP payment for a property, but it appears the client has a license rather than a tenancy. So the client doesn't have exclusive use of the property, only a bedroom, and the homeowner also resides in the property. So it was a verbal agreement only, with no termination provisions or general terms explicitly outlined, and then no tenancy registered with the RTB. So during the emergency period, several attempts were made by the homeowner to evict the client via written notices to quit. Then the client eventually leaves the property with the assistance of the Gardaí and is now accessing homeless services. So the client then lodged a dispute with the RTB for unlawful eviction, but the RTB informed the client that they do not have jurisdiction, as the client has a license agreement and not a tenancy. So then we have to ask ourselves then, so what does the legislation say, and is there anything in the legislation that might be able to help somebody who has such a license agreement? So we'll maybe start off by sort of maybe parking any possible issues regarding HAP and landlord obligations. So we just sort of look just really at how a licensee might be affected by the legislation. So we start off by looking at what does the legislation actually say. So we go to section 5(7)(a). So all evictions, all proposed evictions in all tenancies, including those not covered by the Act of 2004, that's the Residential Tenancies Act, are prohibited for the emergency period. So that's possibly quite encouraging. You know, we're off to a good start there. All evictions are sort of barred for the period. So we'll go then and look at the 2004 Act and then what sorts of rental arrangements were excluded by that. So we then see that the owner-occupied accommodation that our client finds himself in is excluded. So that's okay. So we might be in the correct area now to be seeking protection under the Act. So then we'll look at the government. So what else? The interpretive provisions have been provided around that. So the government issued a guidance document on COVID-19 supports for landlords and tenants. And under section 1.2, paragraph 9, it states that the emergency legislation at 5(7) states that all proposed evictions are prohibited. It is understood that the intent of this provision is to address arrangements which are often described as rent-a-room and dig-style accommodation. So landlords and tenants in such circumstances are asked to show forbearance and support for each other during the emergency period, and where possible, and having regard to the precautions necessary to tackle COVID-19 to avoid termination of accommodation arrangements. So that's also very encouraging. So it seems like the intent of the legislation is to protect the client in a license agreement. However, we'll return then to what the legislation actually means by tenancies. So at the interpretation section, so it's section 3(2), it explicitly broadens the scope of the Residential Tenancies Act 2004 to include student-type licensee accommodation. But that's that's all that's explicitly included there. So there's no reference made in the definition section to any other kind of license agreement. So we find ourselves then now in a grey area where it seems that the intent may be there for licensees to be protected, but the only explicit cover in the Act is for student-type licensee accommodation. So then we have to say, like, our then clients who may be in our rent-a-room or dig-style accommodation, then is there a remedy for them under the legislation who don't have what would be a sort of what you would normally define as a tenancy, so exclusive possession and paying a rent and all the classic features of a tenancy. So a normal recourse for somebody who would have a tenancy dispute would be to refer to the RTB. Now, our client has tried to go down that road and has been told by the RTB that they don't have jurisdiction. So we look at maybe what the RTB themselves have said, and it's not really overly helpful. They essentially restate the government's guidance that the intent is there for rent-a-room and dig style accommodation to be covered, but then encourage property owners and persons renting in such circumstances to try and accommodate each other. So the RTB aren't and haven't been given the powers within the Act to look at these licensee disputes. So our clients then left in a difficult position. So there's no obvious forum to assert their rights. There's no remedy for them under the Act, as the homeowner has not breached any provisions of the Act, and we don't seem to have a recourse with the RTB either. So what can we do? Is there a challenge of the Act itself? Now, that would be a very long, difficult and uncertain road for a client, and it would not necessarily put the client, back in the position in the property. So that's possibly not an option in the short term for a lot of people. Then we look maybe at the district court, and here we have a verbal license agreement. So it might be very difficult to actually prove your case if there were no agreed provisions in place for ending the tenancy. And you might be able to, if you were successful, get some damages, but again, you wouldn't probably be able to get back into the property. So what advice would we give somebody who is in these circumstances? I suppose the advice has to be maybe conservative, take a conservative approach. So the Act says that those with in student accommodation are in, but it doesn't explicitly make reference to other licensees. So the conservative approach would be to say then that they might be out, so they don't have a recourse under the Act. So what do you do then is, I suppose, early engagement with clients who may be at risk. So if a homeowner is threatening to evict a person in this sort of situation, maybe it would be useful to try and quote the language from Section 5.7 saying that evictions are barred for the emergency period, and then to follow that up with quoting from the government's guidance document saying that it's the intent of the legislation that such protection is afforded to licensees, and hope that landlords can, or homeowners can be reasoned with. But as I say, and as Nóra highlighted, it's unclear, and we would probably be recommending a conservative approach. So I'll maybe just leave it there and hand over to Sinead for the next case study.
Yep, perfect. Thanks, Paul. For those of you who I haven't met before, my name is Sinead McGarrigle, and I'm another solicitor from the Mercy Law Resource Centre. I hope everybody can see me there. I can't see myself yet. So I'm just going to run through a case study that I'm currently working on, which involves unlawful occupation of a council house, and I'll explain how the Act is potentially relevant here. So this case involves a young married couple. I'm going to call them Sarah and John. These aren't their real names, but just for the purposes of this exercise. By way of background, the couple have been squatting in the council property since the start of the year because the council have refused to provide them with any kind of social housing support and have refused them access to the social housing list. The council have determined that they have access to alternative accommodation since Sarah's parents are living in a 4-bedroom council house. However, John suffers from mental health issues, and the young married couple understandably don't want to live with Sarah's parents, and Sarah's parents don't want them living with them either. So we're in the process of engaging with the council and pursuing this matter on their behalf. However, in the meantime, before the enactment of the emergency measures legislation, the court instituted possession proceedings to evict the couple from the property they're squatting in under Section 13 of the Housing Act 2014. They were granted a return date in court for the end of September. However, in April, the council successfully applied to the district court for an earlier return date, which falls within the 3-month emergency period. So this brings us on to consider whether there's any kind of defence under the Act which they could rely on. So, in our view, we think that Section 5(7) of the Act does provide some cover to them. It may be that they can use Section 5(7) as a defence to prevent the court granting the possession order, at least until after the emergency period. So let's have a look at Section 5(7) here. I know that Nóra has already gone through this, but I think it would be helpful to maybe look at the text and kind of go through it line by line. So 5(7)(a) states that notwithstanding any of the provisions in this section, all proposed evictions in all tenancies in the state, including those not covered in the Act, are prohibited during the operation of the Act. And then the subsection B says that for the avoidance of doubt, this section applies to all local authorities. So it seems that Section 5(7)(a) and 5(7)(b), when read together, would provide some kind of protection against proposed evictions of local authority tenants. However, in this case, this wouldn't provide any real cover to Sarah and John because they're squatting in the council property, so they actually don't have a tenancy as that term is defined under this Act. So that kind of brings us on to consider whether Section 5(7)(c) provides any assistance, which we think it does. So 5(7)(c) states that for the avoidance of doubt, all travellers who are currently resident in any location should not during this crisis be evicted from that location, except where movement is required to ameliorate hardship and provide protection and subject consultation with the travellers involved. So Sarah and John are members of the travelling community. And although this section clearly envisages the scenario where travellers are living in unauthorised premises, we think that this section could also apply where travellers specifically are squatting in council houses. Section 5(7)(c) is a standalone provision, so it's separate to subsection A and B and appears to actually extend the scope of those previous subsections. Now, if you have a look at the wording, it's quite unclear how long this protection may be provided for. It says during this crisis. And, as was said before, this legislation was rushed through the Houses of the Oireachtas, and that could be unfortunate wording there during this crisis. But we would think that this should extend to at least during the emergency period, if not during the operation of the Act as set out in Section 5(7)(a). Just to note, fortunately for John and Sarah, they've come to an arrangement with the council, so hopefully these possession proceedings that they're facing will be struck out and they won't need to rely on Section 5(7)(a) as any kind of defence. But Section 5(7)(a) would provide some protection against local authority evictions. So I just wanted to mention that briefly, and I'll hand you over to Rebecca, who's going to go through the final case study. Thanks.
Great. Thanks, Sinead. I'm conscious of time, but hopefully this case study will address some of the queries that you have. And I've taken a note of some of the questions we've had in, and we're looking forward to going through those. So this third case study relates to another case that we're involved in. We're working with a client who in February 2020, after being in homeless accommodation for 5 years, moved into a new tenancy off the back of being on the social housing list with an approved housing body. After the emergency legislation was enacted, complaints were received from a neighbour and to her and to the AHB in relation to noise being made by the tenants to young children. A formal warning notice was subsequently served on the tenant, referring to what was termed antisocial behaviour associated with the noise being made by the children. Obviously, this tenant is extremely concerned about her security of tenure. She had obviously been in homelessness for a considerable period, so she had contacted us following on from our previous work with her to find out what are the implications of this for her tenancy. And it should be noted as well that the HB has confirmed to the tenant that the tenancy can be terminated for no reason within the first 6 months of the tenancy. So just to look at how the emergency legislation and some of the other relevant legislative provisions apply here, it's important to note at the outset that this is an approved housing body tenancy which falls under the Residential Tenancies Act. So a 2015 Act brought the AHB tenancies under the remit of the RTB. And so the tenancy is covered by the emergency legislation. Therefore, as we've seen from Nora's comments and the comments of Paul and Sinead, that the AHB as a landlord is prevented during the emergency period from serving a notice of termination. But a consideration arises in relation to how long she's been in the tenancy. The tenancy is not yet a Part 4 tenancy. So she is at risk of termination of tenancy for no reason in the first 6 months of that tenancy, separate to any ASB issue arising. Now, that termination can't take place during the emergency period, but the question arises what might happen after the emergency period, and also whether the time of the emergency period is accruing towards her getting to Part 4 tenancy status, which would obviously give her much greater protection. So Nóra flagged some of the issues arising with the wording of the legislation on this. And under the Act, we feel that for the emergency period, the landlord may argue that the tenant has not accrued time towards a Part 4 tenancy, particularly in circumstances where a warning notice has been served during the emergency period, indicating that the tenancy was at risk. And we should also bear in mind that there is a risk that her tenancy could be terminated for no reason once the emergency period has ended, because she will not yet have reached the six month mark. So there are a number of issues arising in relation to accrual of Part 4 rights. So while the legislation isn't completely clear cut on this, we would just encourage you to be alert to this issue and to refer it on or to discuss it with us and to give it scrutiny yourselves to advise tenants on their security of tenure. So I just want to move on to our Q&A session. We received a number of questions in advance, so I wanted to go through those to start with, and our other panelists are going to join me here. We started a few minutes late, so we have at least 10 minutes to respond to questions, and we're very happy to respond to questions going forward, of course, as well. So I'll just flag and read out the questions that we've received and some that have come up as you've seen on the Q&A box at the bottom of your screen. So we received a query from an HSE social worker who, and I'll read out the question, and it tallies very closely with Patrick's question, which is in the Q&A box. So hopefully the two can be answered just in response to this one. So the question we received in was in relation to a lady that the social worker is supporting who was given notice for her privately rented accommodation in February. So prior to the emergency period, she had to leave her home. She was stated to have to leave on the 20th of August. The reason given is that the owner is going to sell the accommodation. The lady and her 2 children have been living in the house for about 10 years. So the question is, how does the current legislation affect her tenancy? Can she be evicted in August on the basis of the owner selling the property? So I might ask Nóra just to comment on that in relation to how the legislation may apply.
Yes, absolutely. Thanks, Rebecca, and thanks for the questions, both of them. So I'll try and answer the two, I suppose, in one go. So essentially what both questions turn on is where you have a notice of termination that's been served, where the end period of the notice of termination will fall outside of the emergency period. So whether it's still covered under the Act and under the provisions of the Act. And the short answer is that yes, it is. in the circumstances where, if we go to Section 5 of the Act, which says that, and Section 5.2 specifically, says that a notice of termination served before the emergency period, which specifies a termination date that falls during or after the emergency period, the determination date under that notice shall be deemed to be the revised termination date. Then we go to what a revised termination date is, and that's provided for later in Section 5, subsection 6, which says that the revised termination date is the aggregate of, so we add together the period of notice that remains unexpired at the commencement of the emergency period and the emergency period. So in complicated legal language, essentially what we're saying is we add together the period of the notice that hadn't expired at the beginning of the emergency period with the emergency period in itself, and we add that on. So if you're looking at a tenant, I think I can't remember which one, but one of the two tenancies is due to expire in September. What we do is we look at September and we add on the emergency period, because the section 5 applies to a termination after the emergency period as well as one during it, and the revised date is whatever the date would be plus the entire emergency period. So hopefully that answers the questions. And I think for the very lengthy one, I think there was one, the first question was a very lengthy tenancy, and in those circumstances you'd be looking at, it's 224 days or in and around that, and so you'll take that plus the emergency period, and that will be the termination date then. So a new termination date, a revised termination date will apply. So hopefully that answers your question.
Great, thanks, Nóra. We had another question from a colleague at Exchange House, so thanks for that. The question was two-part. The first part I might just comment on. The first part was whether the Emergency Measures Act will be extended, or what is the likelihood of that. I mean, we know from minister statements from early May that there was an indication that it would be extended. Under the Act, I think it's under Section 3, there is a mechanism by which the emergency period can be extended through consultation with the Minister for Health, Minister for Public Expenditure, but we just don't know as yet. So I think Section 4 that procedure set out, we just don't know as yet if it will be extended. And I hear that there are calls just even today in the Dáil for it to be extended. And obviously that would be of huge support to tenants who are struggling at the moment. The second part of the question, I'll just ask Paul and Sinead to comment on. It was just in relation to the favourable outcomes that have arisen for homeless individuals and families in the context of COVID. For example, being able to avail of a rolling bed, a rolling booking. It seems to be that we've had the demise of one night onlys for this period in any event. And I hope that's everybody's experience. And is this a precedent that may have been set? So maybe Sinead and Paul might say a few words just on that.
Yeah, just quite briefly, I've, from my own casework, seen quite a lot of clients moving on from homeless accommodation and especially into HAP accommodation. And what's been really positive here has been the kind of collaborative approach that's we've been able to have with some local authorities, with some frontline key workers. So what I'd be really hopeful of seeing going forward is that continued kind of collaboration with local authorities, especially if there is going to be in a sort of a continued increase or availability in the private rented market.
Thanks. I'll just say a few words on that as well. We have this for families who have been moved out of emergency accommodation into transitional accommodation. So, into houses maybe with approved housing bodies for a 2-year period, while the council try to find something more secure to adequately address their long-term housing needs. And one council representative who I spoke to said that that the availabilities of properties was partly or mainly due, substantially, I suppose, due to short-term rentals coming on the market and being made available to them. So I suppose they've taken advantage of that, and it remains to be seen whether anything further will be done about enforcing those kind of regulations around Airbnb rentals or other maybe short-term rentals. And I just wanted to say, in terms of maybe the one night onlys and the rolling beds, I suppose this crisis kind of shows us what can be done if everyone's collaborating. And I suppose it provides us with ammunition then to query why this can't continue, and maybe to push it forward on a policy basis.
Thanks very much. I have 4 further questions marked, and I hope that we can just go through them quickly to respond to the questions that come in. I think we'll deal with any further ones. I know Circa from the Offaly Traveller Movement. Hi, Circa. You just had a query about whether local authorities can still send correspondence to tenants about eviction. I know our case study somewhat dealt with that, but I just wonder if, Sinead, you had a line on correspondence particularly.
Yeah, sure. I think I saw your comment or your question come up, Saoirse. And it seems that maybe a tenancy warning has been sent, or something similar to that, to tenants who did a swap. I think the wording of Section 5.7 is quite vague, and it refers to proposed tenancies. So I think there is scope to kind of push back on that, and maybe send a letter back to the council kind of saying that they can't be evicted at this time. But in terms of whether the correspondence can be sent, I think the answer is yes. They can still send the tenancy warnings, and they can let them know that their obligations have been breached, and then I suppose they can't actually seek to evict them at this time until after the emergency period, or actually, because it's 5.7, until that section is repealed or until the Act is repealed.
Thanks, Sinead. We had 2 questions that were also quite similar, querying the warning period increase from 14 days to 28 days, and whether that will be for the emergency period only or for the duration of the Act. And just to comment on that, my understanding is that provision refers to warnings in relation to arrears of rent being served on tenants who are not yet Part 4 don't yet have Part 4 tenancies. So that's the area that it's referring to. It's Section 6.5 of the Act, and it specifically says it's for the duration of the emergency period. So I hope that helps answer the question there. Another question was in, and do come back to us if you have follow-up questions, the 2 people who raised that. Then we also had another question about whether HAP tenancies, all HAP tenancies are license agreements. I might ask Paul, and perhaps Nóra would just make a quick comment on the distinctions between license agreements and tenancies and the relationship with HAP. I think it's an important qualification.
Yeah, just to say briefly, I suppose from what you're not excluded under the HAP provisions from entering into a license agreement. So you can have a veil of HAP where you share the homeowner's home. But I think the vast majority of HAP people availing of HAP are in tenancies rather than license agreements. And maybe if Nóra wants to just draw the distinction between license and a lease.
Yeah, absolutely. So in terms of the distinction between the two, I mean, the key kind of effect of it is whether you fall under the 2004 Act or not. And so you may have, as a tenant, you have, and you don't necessarily have to have a written lease and so on, but you have very clear rights, and you also have very clear obligations arising under the 2004 Act, because you're defined as a tenant within the meaning of that Act, whereas a license agreement is permission to use a property and to reside in a property, but you don't have rights over it in that sense. And so you don't fall under the provisions of the 2004 Act, with the exception of some student accommodation, which is falling under it, and certainly is clearly falling under it for the purposes of the emergency legislation. And I suppose the stereotypical examples are, living in a rent a room scheme and so on. But I think actually in terms of the HAP issue, I think that was kind of in some ways neatly covered by the case study that we've gone through already, and that you have somebody who isn't prevented from having HAP within a rent a room type situation, but may face difficulties in terms of enforcing anything under the emergency legislation, where the RTB is saying, well, look, you don't fall within our remit. So it certainly does present some difficulties under the emergency legislation anyway.
Just to add slightly on that, the vast majority of HAP tenancies we see are not license agreements. So we were in ourselves looking at that just to review and that you can get HAP if you're on a license agreement. So that was a learning from our side. 2 questions that we'll finish up with. The first one I might ask Nóra just to comment on. The question is, if the period of the Act is finished or the Act is repealed, can complaints about breaches of the Act still be made, remedy awarded or enforced? So that might refer back to your remedies section.
I mean, I would think it depends to an extent about who's trying to enforce them. So for the most part, I think the answer is yes. Because if let's say the Act has ended, the emergency period has ended, and indeed the Act itself has been repealed, if you were served with a notice of termination during this period while the Act was in force, that is still an invalid notice of termination. So even if that is, so let's say you're served with it now and actually you have a really long tenancy, so you've been there for 10 years, so you have another 224 days to go before that's given effect to. The legislation ends in the meantime, you still have a remedy to go because there has been an unlawful notice of termination granted. So I would think now I would need to look through it kind of section by section because some of them are defined as the emergency period, and some of the protections are defined as within the period of the Act, and those two may differ. We don't know exactly when they'll end, so there may be differences, but certainly in broad terms I would think that you should be able to rely upon, certainly in terms of a notice of termination or an unlawful eviction, you should still have the same remedies in terms of going to the RTB and so on, after the period of the Act ending or the emergency period ending.
Great, thanks, Nóra. And just the last question, I know we're up against the clock, from Thomas, also with the HSE. He asked, if a mental health service user is admitted into hospital during this period, which may be for an extended period, can the owner of the property initiate a notice for termination? Now, I might say a comment and maybe Nóra to add. I mean, myself and Nóra have actually had a very similar case in times gone past, and unfortunately in that case, it was a tenant of an approved housing body who was served with a notice of termination, having been sectioned under Mental Health Acts and was in hospital as an inpatient. And unfortunately in that case, the RTB upheld the validity of that notice. Unfortunately, a resolution did ultimately come out of it, and there are a number of different issues in the case. But my sense of it is that it can be. But obviously, during the emergency period, no notice of termination can be served under the Act. So during the emergency period, there's an absolute cessation on any notice of termination being served. Nóra, you might want to have the final word on that one.
No, I mean, I agree totally. I don't really have much to add other than to say, yes, exactly. So it doesn't matter what the tenant circumstances are. The fact of the matter is that during the emergency period, no notice of termination can be served under Section 5.1 and no proposed eviction under Section 8 for the duration of the legislation. So I would think that, any proposed eviction or any notice of termination served within this period is presumptively invalid, whether or not somebody is an inpatient or otherwise, that won't have an impact on it. There's nothing in the legislation that would, or nothing in the residential tenancies provisions of the legislation that would have any impact on that I can see.
Great, so we'll wrap up now. We're just over time. Just to say a big thank you to Nóra for giving your time this morning and your input and your expertise. A big thank you to my colleagues, but also a big thank you to you all for joining the webinar. Thanks for all the questions, they're all very on point. And do please keep in touch. If you have individual cases you want to speak to us about, you have our contact details, just get in touch. And if you're interested in further online training at all, do get in touch with us as well. Hope everybody has a great day, and many thanks. Bye now.